Hello, folks. Welcome as you all are coming in. Just as we have you join us, feel free to go ahead and just say hello in the chat. Tell us where you're zooming in from, and we'll get started very briefly. Welcome, folks. All right, I see we got some folks from Outer Sunset, from New York, Redwood City. Look at that. Fantastic.
कुछ आ गया उसका समझ में नहीं आया कॉपी पेस्ट करता है क्या सबके लिए
Miami.
From Miami, okay. Hello. Welcome.
Hi, Tiburon.
Oh, Tiburon. Oh, amazing. Great.
Hi, I'm from New York.
From New York. Hey, welcome. All right. Well, I'm going to go ahead and get us started with our event for today. I'm very glad that we're all able to be gathered here, even in a virtual space online today, to talk about art and justice. And it feels exciting to be talking about art and justice now, as always. These are topics that are always important to think about. But as we're sort of in the wake of a historic transition of power in the US, law, storytelling, all of these questions they take on fascinating meaning as they are, as always. And I feel very grateful to be here with Mary Kathryn Nagle and Pellegrini and Eleanor Wong to talk about performance and the law and how those two might enter into dialogue. My name is Kari Barclay. I use he, him, or they, them pronouns. I'm a fifth-year PhD student in theater and performance studies at Stanford University. I am joined by Anna Kimmel, who is another organizer for this Arts and Justice series, for which this is our first event of 2021. The series has our faculty sponsor of Jisha Menon, who's been wonderful in organizing the event, coming up with different ideas, and helping make this possible. So thank you so much, Dr. Menon, for all the support. This series, Arts and Justice, is sponsored by the Stanford Humanities Center and is a year-long series bringing together artists and scholars to examine questions of what art and justice mean for us and how they can enter in conversation together. I would also like to acknowledge that Stanford University is on the land of the Ohlone people and offer you all a chance in our audience, for those who are in North America, to recognize the native land that you are on and you were giving that you are zooming in from today, in the same way that you kind of gave some introductions in the chat. Feel free to put that in order to recognize the legacies of Indigenous land that you're on. So with that said, I'm going to go ahead for the format of today, go ahead and introduce folks. And then each of them is going to give some introductory remarks. And afterwards, we'll move into a Q&A in which you all will get the chance to ask some questions. For now, please mute yourself, although we love seeing your faces. So if you do want to turn your video on so we can see you listening, I can kind of create a little bit of more of a feel of community. So feel free to go ahead and do that. And with that said, I'll go ahead and introduce our first speaker. So I'm very glad that we're able to be joined today by Mary Kathryn Nagle, who will be giving a talk entitled Native Theater: Using Performance to Change the False Narratives That Form Prejudicial Laws. Mary Kathryn is an enrolled citizen of the Cherokee Nation and a playwright. She is the author of several plays, including Sliver of a Full Moon, Mannahatta, and Sovereignty, which for folks in the Bay was at Marin Theater Company up in north of San Francisco. She has done work at so many theaters and has an amazing number of commissions. I'll just name a few: Arena Stage, Yale Repertory Theatre, Roundhouse Theatre, and the Oregon Shakespeare Festival. She has also served as the first executive director of the Yale Indigenous Performing Arts Program. She is as well a member of Pipestem Law, PC, where she works to protect tribal sovereignty and the inherent rights of Indian nations to protect their women and children from domestic violence and sexual assault. Very grateful to have Mary Kathryn Nagle here today, and I'd like to welcome her to Stanford.
Thank you so much. That's quite the introduction. Thank you all. It's just wonderful to be here and to see everyone online tuning in for this conversation. It's still these are historic times, and I think connecting and having these conversations is so important. I don't know what folks were doing last night, but I just sat like a baby and watched all the amazing artists sing and celebrate this new administration and this new moment we have in this country. And I just think if you were watching it all last night, I couldn't stop. I think it's very clear the power that arts have. And I think it was very clear the message that President Biden and Vice President Harris wanted to send in creating an arts presentation that was so inclusive of different voices. And certainly I think we could find ways to critique it and say who it did not include, but I think that's not the point here. The point is that they were intentionally working to include many different voices and to celebrate this new moment in our country through arts and through storytelling, which is song. And I think, stepping back from that and thinking about where we are as a nation right now, I will say that, being a citizen of the Cherokee Nation, you can chart a direct path between, you can show our greatest tragedies, the Trail of Tears, for instance, where, a fourth of our nation was killed by US soldiers or died of disease when we were forcibly removed from our homes at gunpoint. That was the direct result of President Andrew Jackson at the time refusing to enforce a Supreme Court decision that we had won. So we had actually won in the courts and yet couldn't get the United States president to obey the United States Supreme Court. And that led to a great and serious tragedy for our nation and a real loss of life and our land, our homelands, where we had lived since time immemorial. And what else was happening at that moment? And I would make the argument, and I've looked at this, and I think one of the best scholars out there who's documented it from the performance side is Dr. Bethany Hughes, who is a citizen of the Choctaw Nation and currently is a professor now at the University of Michigan. But I sort of started this, I didn't start it, a lot of us were working on this together, started using this hashtag instead of red face. It's been very problematic for me to see, and when I don't live in New York now, and certainly, unfortunately, our theaters are shut down, but I did live in New York for 5 years from 2010 to 2015. I didn't once see a professional theater in New York that wasn't a Native theater. We have a couple of Native theaters who, do an amazing job begging and pleading for money wherever they can, scraping together pennies to do a $35,000 off-Broadway production, and at a theater like 59, which gives us a very nice discount. So we get Native theater out there, but I'm talking about the public theater. I'm talking about the Atlantic. I'm talking, let's just name all these off-Broadway professional theaters that when I was living there didn't produce a single play by a Native playwright. I did, however, see repeated performances of red face. I could sit here and list them all, but that's not as interesting, and I don't want to pay attention to the red face or draw attention to it. But just to note that it's there, and so what I've been saying is, unfortunately, and thank you so much. I see someone just put Bethany Hughes in the chat. Thank you so much. She's amazing. I definitely recommend her work. What Bethany has done is, I've always said, red face is what allowed the legal framework to be set in place that allowed for genocide. You don't get to have genocide, right, unless you have a culture that says we embrace that legal framework, we support that legal framework. That legal framework reflects my values. And how did we get to an American culture where most Americans would say, yes, genocide reflects my cultural values, my moral values as a person? Well, you have to dehumanize someone. and red face was used to do that. So right before, now, hundreds of tribal nations had their own Trail of Tears. The Cherokee Nation one happens to be the most well-known. And I'm a citizen of the Cherokee Nation and a direct descendant of the small fraction of folks who survived that. But again, I don't want to make it sound like it was just a Cherokee Nation story. This was like pretty much every tribal nation story. But in Cherokee Nation's instance, what were the events leading right up to our removal? Well, if you look in the 1820s, when President Andrew Jackson, who refused to enforce the Supreme Court decision that we won, that guaranteed our sovereign right to exist on our ancestral homelands and to stay in those homelands and to not be removed, and prohibited the state of Georgia from exercising any jurisdiction on Cherokee Nation lands. That was Wooster v. Georgia in 1832, a case we clearly won in the Supreme Court. Andrew Jackson, the president that refused to enforce the Supreme Court's decision and basically told Georgia, do whatever you want. I don't care what the Supreme Court just said. I'm removing the federal marshals. I'm removing the federal law enforcement who should be enforcing the law. Georgia, I will look the other way. You do whatever you want. How did we get to that kind of a president? Well, if you look back at his campaign in 1828, he ran on a platform of, I will annihilate tribal nations. I will remove them. They're savages. They're racially inferior. You, white Americans, are superior to them. We will remove them for you. Vote for me. Today we've heard a lot more things in the last 4 years that I think people thought, oh, we're done with that, which we never fully were, right? But certainly Andrew Jackson's talk in the 1820s, I think a lot of people still are like, well, he said that? Of course he said that. Go back and read his speeches. He was very direct. He's like, these people are racially inferior to you. I will remove them. Vote for me for president. And then he won. And that was a major part of his platform. At that moment, in the late 1820s, the most popular performance on Broadway was a performance of Red Face. And that's not a coincidence. That's cause and effect, okay? And that's something that Bethany Hughes has written at length about. And it was just kind of cool when we actually met up a few years ago, because I sort of had this thesis, and I, as a lawyer and a playwright, I'm like, I really think this is true. And then she wrote me this email, and she's like, well, I'm doing my PhD dissertation on this. Did you know that Metamora was the most popular performance in the 1820s? And I was like, exactly. Okay. So I encourage folks to read her scholarship, because I sort of talk about it anecdotally, and she's done the research to document it. But that's true of blackface too, right? Why was blackface invented? Blackface was invented to create a culture that would accept slavery, right? And then later on, of course, segregation. And you can't have a system of laws that says these people are inferior to these people unless you have a culture that accepts it. And arts, that's how we shape our culture. And so I think that's really, really critical to realize, because we still have progress left to make in this country on many fronts, whether it's Native issues, whether it's LGBTQIA issues, whether it's, other racial issues, people of color. I mean, we've got, women's rights, we've got immigrants' rights, we've got, we could all sit here and come up with a list of places where America needs to make progress, right? That list is long. I'm very thankful that I think we're seeing a lot more solidarity these days, especially in the area of performance. This is an exciting time to be alive and making theater. I have to say, it was so nice to hear the list of places where I've had commissions, and that's so exciting. That's been within the last 5 years. And I think, we're starting to see, for instance, when Arena Stage produced my play Sovereignty, that was the first time they had produced a play by a Native playwright. And that was 2 years ago. Well, 3 years ago. That was 3 years ago. When the Oregon Shakespeare Festival produced a musical by Randy Reinholtz, who's a Choctaw Nation citizen, that was the first time Oregon Shakespeare Festival had produced ever in its entire lifetime, ever produced a single play by a Native playwright. Since then, we've had Portland Center Stage produced a play by Delana Studi, who's also a Cherokee Nation citizen. That would have been in 2018, and that was their first time Portland Center Stage ever produced a Native playwright. Larissa Fasthorse is sort of like blowing apart all the records, and I mean, I think, you know, Kansas City Rep, Playwrights Horizons, you could just sort of list all the places she's gotten produced, and I'd have to look at it to verify. I'm pretty sure she was the first Native playwright to get produced at those theaters. What is my point? My point is, you know, 5 or 10 years ago, I would say very few, maybe a tiny handful of professional non-Native mainstream American theaters had ever produced a play by a Native playwright. We've now expanded that. We went from like 0 or 1, maybe 2 to like 10 or maybe 15. I haven't actually sat down to create the list. But what I can tell you, we're seeing explosive growth. We're going from like basically 0 to a substantive list that we're starting to create. But there are a ton of theaters that have never produced their first Native playwright. And that's pretty remarkable when you consider the country that we live in, and that, you know, like Native people are the first storytellers, right? What does that mean? I mean, you know, I can say very clearly there's a direct line between that and the fact that Native women are more likely to be sexually assaulted, raped, and murdered than any other population in the United States. Why? Because the United States Supreme Court in 1978 said that our tribal nations can no longer exercise criminal jurisdiction over non-Indians who come onto tribal lands and commit crimes. And after that, after 1978, basically non-Indian criminals realized, I can rape, kill, murder Native women on tribal lands with impunity. The tribal government doesn't have jurisdiction to arrest me. And the Department of Justice has actually documented in the last 10 years that Native women experience the highest rates of sexual assault, domestic violence, and murder, and that the majority of these violent crimes are being committed by non-Indians. But the Supreme Court took that jurisdiction away. And it's a twofold problem, right? Because the justices in 1978 and Chief Justice Rehnquist, who wrote that opinion, you know, didn't study Indian law or issues related to tribal sovereignty in law school, right? So we're erased from the curriculum. But those justices all go to theater, right? They absorb the arts. So when we're also erased from the arts, let me tell you, that has a huge, huge impact on the humans who make decisions about the law. And I think one of my greatest hopes, and I will wrap it up because I know we got lots of other amazing speakers and we'll have time for Q&A. But I think I feel like I was sort of a playwright in lawyer's clothing for a long time. So I've sort of had these dual identities of playwright and lawyer. And I just always saw the connection between the two. And there's many things I could talk about. First of all, I mean, the only way to be a good lawyer is to be a good storyteller. You know, like you basically need to study playwriting or forget it. You're never going to succeed as a lawyer because you have to be able to tell your client's story. There has to be a compelling story. You can't just say, well, the law says this, right? And you have to know your audience. And if your audience is, you know, a bunch of justices whose idea of a Native American woman is Pocahontas from Disney's movie, you're in trouble. You're in trouble because you're not, even though Pocahontas was a real person, she herself has been dehumanized. Her actual story's been erased and been replaced with a Disney cartoon that's not based on truth. And, you know, now, you know, our former president's use of her as a political football against his, you know, political opponent, Elizabeth Warren, when Pocahontas should never have even been a part of that conversation. But one of the things I will say that just, I think, really cements the role that the arts and performance have when it comes to changing the law or affecting the law or the relationship is one of the blessings I had when we did my play Sovereignty at Arena Stage in January of 2018. And I didn't find out until after it happened. Justice Ginsburg came to one of the performances. And of course, it was like a performance that I had missed. And so she's backstage taking photos with the cast and they're all putting it up on Twitter. And I'm just like, how am I not here for this? And but she wrote me the nicest note afterwards. And she just said, I was really, I loved your play. I mean, I have it, of course, but I don't have it with me right this second. But, she basically, I love your play. And it really made me think about the connection between sovereignty and safety for Native women and blah, blah, blah. And I don't think it's any coincidence that just a year later, she authored the majority opinion in a very critical case where it was about a perpetrator of domestic violence against Native women. And I could get into the statutory analysis, but it's about a very nuanced section of the Violence Against Women Act from the 2005 authorization. And I actually filed one of the amicus briefs on behalf of my client, the National Indigenous Women's Resource Center, in that case. But she, I mean, her opinion, this was like a year later, was just connecting all the dots that I felt like I'd never seen her or anyone on the court quite write a decision like that. That's called United States v. Bryant. Little known case of hers because, again, it really kind of dealt with safety for Native women. And I think really those of us in Indian country were like, hooray, but probably outside of Indian country, most people, you know, it's not the kind of Supreme Court case that most people are going to look at. But, you know, can I take credit for that because she came to see my play? No, I can't like publicly say, well, you know, that's because she saw my play. But I just, on a gut level, think that it made a difference. And I think that as artists, we speak to everyone, right? Judges, educators, doctors, you know, people involved in all kinds of important services in our communities. You know, you name it, right? We're communicating those stories. And I just think we are creating the social fabric that will propel us as a country to move forward and make progress and get rid of some of the harmful laws that we still have on the books in this country. Or if those stories don't get out there, we'll impede that progress or even reverse it, right? And so I think I will conclude there and look forward to what my other panelists have to say and talking in the talkback. But thank you all so much for joining us tonight. Thank you so much, Mary Kathryn. Make some give a silent round of applause as best as you are able. I appreciate that story about Ruth Bader Ginsburg at the performance. I'm originally from the DC area, and I think something that the theater community actually really feels there is the presence of lawyers, the presence of people in politics in the town. And so it's you have some very interesting political engagement that I think has been increasing in recent years, that you're able to spark some of that dialogue. So thank you so much. All right, so I see somebody's asking in the chat, the artist of the work behind you, Mary Kathryn, but you can perhaps pop that in the chat. I'll go ahead and introduce our next speaker. I'm very glad that we have here with us today Anne Pellegrini, who will be giving a talk entitled Fire in a Theater. Anne Pellegrini is a professor of performance studies and of social and cultural analysis at New York University. Her books include Performance Anxieties, Staging Psychoanalysis, Staging Race, Staging Psychoanalysis, Staging Race, Love the Sin, Sex Regulation and the Limits of Religious Tolerance, and You Can Tell Just by Looking, and 20 Other Myths about LGBT life and people. So co-authored with Michael Bronski and Michael Amico. And You Can Tell Just by Looking was a Lambda Literary Award finalist in LGBT nonfiction in 2014, which is a tremendous honor. And as well, she is a candidate in adult psychoanalysis at the Institute for Psychoanalytic Training and Research in New York City, and was just talking with us about being in clinical practice yesterday. Thank you so much, Anne, for joining us, and please welcome Anne to the virtual Zoom room.
Oh, thank you so much. Let me begin by thanking Kari and Anna and Jusha for the invitation to be part of this evening's conversation. It's an honor to be in this particular Zoomiverse with all of you and with such wonderful co-panelists. I'm excited to learn from them and to workshop some questions that are lately preoccupying me about free speech, fake news, and public feelings. Some of my remarks will be more sort of notational because I'm really just trying to thread together a set of things that I think go together. I'm not quite sure exactly how, so I'm really excited to sort of have a conversation with all of you about this. And I'm already I already want to jump into the discussion and actually ask Mary Kathryn about, I was just so moved by what she was saying about the extra legal, like what happens outside the space of the law that can change the law. And so already excited about the conversation to come. But I've organized my own brief formal remarks around 3 fires in the theater. The first fire, I'll begin in 1919 with one of the most famous phrases in Supreme Court history, quote, "The most stringent protection of free speech would not protect a man in falsely shouting fire in a crowded theater and causing a panic. This statement, issued by Justice Oliver Wendell Holmes in the 1919 Supreme Court case, Schenck versus the United States, has become so well known and so frequently repeated. Do a Google search to see what I mean, though please don't do it right now, right? It's become so well known and so frequently repeated that it's floated free of its initial context, kindling all manner of misunderstandings about the power of the state to regulate dissenting political speech. For that indeed, what was the stakes of Schenck v. US? What kinds of speech could the state regulate? Schenck was one of a series of landmark free speech cases taken up by the Supreme Court in the immediate aftermath of World War I. So though it took up these cases in 1919, a set of cases, the cases all arose during World War I. These were cases that specifically had to do with a set of laws that had been put into place during World War I that were, in the words of legal theorist Timothy Wu, speech control programs, right? So these cases that came to the court were considering the legitimacy of government speech control programs. And what's important is that these speech control programs included both a negative prong, here we can think of the Espionage Act of 1917 and the amended Sedition Act of 1918, both of which criminalized voicing opposition to World War I. And we can think of a positive prong. This was a huge domestic propaganda campaign created by executive order by President Wilson, whose goal was to ensure the commitment of all patriotic Americans to the war effort. At one point, this program employed 150,000 federal workers. Now, under the Espionage and Sedition Acts, hundreds of American citizens and recent immigrants who were not yet citizens were arrested, tried, convicted, and sentenced to long terms in prison for dissenting from the war effort. Charles Schenck, whose name famously adorns Schenck v. US, was one such political dissenter. The General Secretary of the Socialist Party, Schenck was charged with mailing 15,000 leaflets to potential draftees, urging them to resist conscription, right? And in the leaflet, which he helped to write and mail, the leaflet described conscription as, and I'm quoting, all right, so I'm going to quote from the leaflet, as quoted by Justice Holmes in his opinion. I think this is important to think about the quoting of a quoting, because that's actually part of what I'm interested in thinking about tonight. So in his very short 7-page opinion, Holmes spent some time describing what was in the leaflets. So the leaflet, which was urging potential draftees to resist being conscripted, described the draft as despotism, I'm quoting, despotism in its worst form, and a monstrous wrong against humanity in the interests of Wall Street's chosen few, close quote. The leaflet urged no violent action, confining itself to urging a petition to repeal the Conscription Act and telling the reader, the potential draftee, to, quote, assert your rights. Now, Holmes himself agreed that nothing in the leaflet explicitly called for violence, right? And I think this is important. Both Schenck and Elizabeth Baer, she was another member of the Socialist Party's executive committee, they were both convicted and sentenced to 10 years in prison for obstructing the draft, an activity explicitly proscribed under the Espionage Act of 1917. Both appealed their convictions. That appeal ended up eventually in the Supreme Court of the United States. There they argued that the Espionage Act was in violation of the First Amendment's promised right to the free circulation of speech, even speech critical of the government. And it's important, they were asserting the First Amendment free speech right, but they were also asserting a right that was of freedom of the press, because this was, the leaflet was being circulated through the mail, and in that sense had a component that went beyond the bounds of an individual speech act as it circulated to a wider public. Now, a unanimous court found against Schenck and Baer, holding that different circumstances called for different analyses of speech's limits. And it's at this juncture that Holmes introduced his famous phrase. And now I'll quote directly from Holmes's opinion, right? He writes, "We admit that in many places and in ordinary times, the defendants in saying all that was said in the circular would have been within their constitutional rights. But the character of every act depends upon the circumstances in which it is done. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic." So that's the immediate context in in which that statement arises. And I think this is important. That famous line that you can't falsely shout fire in a crowded theater, a line that it's repeated over and over and over again outside the law, speaking of the extra legal, right? This is in fact an analogy through which Justice Holmes builds the legal analysis of why the government can sanction politically unpopular speech and harshly punish the speakers. And remember, Schenck and Baer were sentenced to 10 years in prison. That's no slight punishment at all. Now, Schenck is significant for many reasons. It was the first time that the Supreme Court considered a free speech challenge to a federal law. So it's actually setting precedent in this case, and that's very important. The analysis developed by the court represents the first significant interpretation of the free speech clause in United States history, right? This is the first significant interpretation of what limits the government could permissibly set on political speech. And this was explicitly about political speech. Issues of commercial speech arose later in Supreme Court jurisprudence about the First Amendment. Right? Again, writing for a unanimous court, Holmes developed a standard of clear and present danger. This is, and in fact, this case is most famous, even if the most famous line from the case has to do with you can't falsely shout fire in a crowded theater. In terms of its legal legacy, it became famous for a clear and present danger test, right? Which he enunciated. That is, the government could censor and even criminalize speech that represented, quote, a clear and present danger to bring about some, I'm quoting Holmes, some substantive evils that Congress has a right to prevent. And what that means, Congress has a right to prevent, is basically that Congress might be interested in preventing all manner of things, but it doesn't have a right to prevent. So the only speech, the speech that is sanctioned is speech that presents a clear and present danger to produce kinds of illegal acts that Congress is already constitutionally permitted to prescribe. Right. Now, the clear and present danger of the anti-war leaflets are, and this is in the setup of Holmes's rhetoric, equivalent to falsely yelling fire and causing panic in a crowded theater. That's part of the setup. And I would suggest that falsely yelling fire and causing panic in a crowded theater sounds actually politically neutral, right? It seems almost innocent. I mean, who wouldn't think it's actually wrong and even dangerous to yell fire when there's no fire and with deliberation cause panic in a crowded space, right? So there's an innocence to that initial analogy that helps to anchor an incredibly pernicious legal decision, right? And as I mentioned earlier, this phrase, you can't falsely yell fire in a crowded theater, has taken on a life of its own, unmoored from the ugly legal decision that it helped to anchor. It's taken on a life of its own, it's floated free. But so every time you hear reference to this, you can't yell fire in a crowded theater, right? As something where the Supreme Court draws the line between protected and unprotected speech, we have to do some work to bring back in the larger legal context, which was about empowering the government to not only censor, quote, unpatriotic speech, but to harshly sanction those who spoke it. And I think this actually might connect in some interesting ways to some of the issues that Mary Kathryn was just discussing about the forms of forgetting, the forms of the forgetting that are sanctioned and performed through violence, right? And that the law is part of, right? Now, the logic of Schenck, that the clear and present danger test, empowering the government actually to sanction and harshly punish speech that is unpatriotic. This would be furthered in two other free speech challenges to the Espionage Act that came before the court in 1919, with Holmes again taking the lead. But he did very soon thereafter, still in 1919, he was a busy guy in free speech cases, end up switching sides, coming to argue ultimately in favor of protections for political speech in another 1919 case. That's Abrams v. United States. This, I'm happy to talk about that in our discussion, but this was also a case in which a very harsh sentence was given, in this case, to two Russian immigrants who were opposing US military action in Russia shortly after the Russian Revolution in 1918. The revolution in 1917, but the US engaged in military action in 1918. Two Russian immigrants drop a leaflet opposing this. They end up being arrested and charged under the Espionage Act. They're sentenced to 20 years in prison, right? Now, Holmes dissents in that case. He's on the losing side, he dissents. But in many respects, His analysis won. So he's moving away. He doesn't sort of back away from the clear and present danger test, which he developed and which is actually drawn on by the majority in Abrams. Instead, he says, well, this case is different. There are only 2 men. They dropped only 2 leaflets. So it wasn't enough of a present danger. I mean, what could it really do? So, and also you can hear him trying to back away from precisely the state force he had earlier authorized in Schenck. He writes, let's not trust the state to censor speech. We don't need the state. Instead, he wrote, quote, the best test of truth is the power of the thought to get itself accepted in the competition of the market, right? The best test of truth is the power of the thought to get itself accepted in the competition of the market, right? Now this pushing forward of the market, the invisible hand of the market, is that which we can trust to regulate speech, not the government. In some sense, this has won the day. Some other intermediate cases to do with free speech and government regulation were in between, most famously Brandenburg, the Ohio in 1969, which effectively overturns the rulings in Schenck and the companion cases in 1919. But Holmes's dissent, advocating trusting the invisible hand of the market to keep the dangers of bad speech at bay, this is ultimately the logic that the court has recently been drawing on. It's become in some ways the dominant position. In 2012, for example, then Justice Kennedy cited Holmes's dissent and expanded on it in the case of US v. Alvarez. He writes, the remedy for speech that is false is speech that is true. That is the ordinary course in a free society. The response to the unreasoned is the rational, to the uninformed, the enlightened, to the straight out lie, the simple truth, right? So here Kennedy puts his faith, and then he quotes Holmes right after that. He puts his faith in the court's backing behind the free hand of the market, which he held could be trusted to drive false speech to the margins. But what if the free hand of the market is also the presidential thumb, right? The second fire, about which I will say less because I'm aware that I'm quickly running into my 15-minute time limit. So in a press release issued on January 12th, Liz Cheney announced she would vote in favor of then President Trump's impeachment, saying, quote, the President of the United States summoned this mob, assembled the mob, and lit the flame of this attack. So I'm associating from the flame of this attack to the earlier drawing on the question of fire, the fire of incitement that Holmes wrote into Supreme Court jurisprudence around free speech. What kinds of speech is permissible and what isn't? And the question of the fire bomb, the speech that becomes fire, the speech that becomes deed and is no longer word, but only action, pure action. This is part of what haunts, and I would say actually runs beneath and incites in its own way, the rhetoric of Cheney at this moment. And the linkage between this, I love getting to say this, the former President Trump, how lovely to say those words, the linkage between former President Trump and the famous line from Holmes, yelling fire in a theater. Now, if you want to Google it, go ahead, but Google Trump and yelling fire in a crowded theater, you will find numerous references pop up, including a Vanity Fair headline from September of 2020. Trump is the human embodiment of yelling fire in a crowded theater, which drew on a joke by late night host Seth Meyers. There's a recent piece in Newsweek in January of 2021, Alan Dershowitz, longtime Trump defender, saying Trump did not shout fire and criticizing the legal analysis of Trump as performing any kind of incitement and also criticizing the use of that earlier analogy, right? So I'm really interested in the ongoing circulation of that earlier rhetoric of Holmes and also the inadequacy of this earlier generation of Supreme Court analysis to the new context in which speech circulates virally, right? And too much marketized, right? So how, I mean, I think this is a pressing question. How do we think about the ways in which the marketization of speech, like the cheapness of speech, in some sense is raising questions of regulatory questions, but we don't want to go back the route that was taken earlier in the court's life, which empowered the government to censor speech and harshly punish actors. So how are we to think about the kinds of fires that are daily being lit? Fires that in fact sort of push forward violence, that empower hateful violence, not just hateful thought, right? And my third fire, in conclusion, And I suppose we'll drop back to World War I here. This is 1915. There's a really fascinating passage in Freud's essay on transference love, in which he too invokes the notion of the eruption of fire in the theater. And he's talking about what happens in the transference when in this instance, when the patient comes to believe that she is in love with the analyst. And he says, Freud is initially talking about how this love relation, the patient's conviction that she's in love, basically stops the show. It stops the make-believe of the analysis. Here's the Strachey translation. Because of this conviction that she is in love with the analyst, there is a complete change of scene. It is as though some piece of make-believe had been stopped by the sudden eruption of reality, as when, for instance, a cry of fire is raised during a theatrical performance, right? So we've got the make-believe of the analysis, then the eruption of reality. Freud will go on to suggest that actually there's an ambiguity between the real and the make-believe. Maybe in this era we could speak of the false and the true. And that ambiguity, rather than being something that we should run away from, I suppose in the language of psychoanalysis, resist, is precisely the place where we have to do the work. So this essay is written to advise the analyst, the one who listens, the one around whom this fire is erupting, because the patient's convinced, I am in love with you, it's real, rather than panic, to stay still in the discomfort of this and to work in the space between the real and the fictive. And I wonder if there's something we can draw on here, how to sort of play with the fires in the theater of our shared public life, of our common world, and to do so in ways that don't invoke the power of government to sanction, to punish, but allow for the development of new, forms of contact, new ways of staying with the discomfort of otherness. And I'll end here. Thanks so much.
Thank you so much, and I really appreciate the timely thinking about incitement and how and thinking incitement throughout history. And I think it's fascinating for me to hear talking about a crowded theater versus the marketplace. And does a theater become a marketplace? Is the marketplace itself a theater? How do we think of all these things? So a lot for us to unpack, and I'm really grateful to hear those thoughts and to bring them in conversation here. I'll go ahead and introduce our last speaker, Eleanor Wong, who is going to talk today a little bit about the history of theater in Singapore, and specifically her work that crosses over theater and the legal profession. So Eleanor Wong is the author of a trilogy of plays called An Invitation to Treat, whose plays include Mergers and Accusation and Wills and Succession, and lastly, Jointly and Severably. So playing with some of these legal languages, they explore questions of the law, questions of female sexuality, questions of gender in relationship to the law, and a lot of things that I'm excited to hear a little bit more about today. Wong was also a writer in residence at the Center for Quantum Technologies at the National University of Singapore, and currently is director for the Legal Writing Program and Vice Dean of Student Affairs at the National University of Singapore Faculty of Law. Welcome, Eleanor. We're really excited to hear from you. I think you're still muted.
Yeah. Hello from Singapore, where it is 8:30 a.m. in the morning, and thank you so much to the organizers for inviting me and including me in this session, something that we couldn't have done or wouldn't have thought of doing a year ago, and perhaps one of the blessings that balance out Zoom fatigue. I'm also grateful to the organizers for arranging the last night's presidential inauguration as a warm-up act, but I realize the privilege and the pressure that puts on us. I'm really a trained lawyer and an untrained playwright. As a lawyer, I graduated from my university here in Singapore, the National University of Singapore, and I started my career as a prosecutor of corporate crimes. I also do have some connection with your wonderful country. I obtained a master's from NYU in New York City. I lived and worked there for a while with some US law firms. before returning to Singapore to do some regional finance work, and then to come back to my alma mater to start its legal skills program, which really I tell people, I don't know any or teach any substantive law. It's really about the sort of thinking and research and communication skills that cut across law content, and actually I try to get away with knowing as little law as possible. So I'm acutely aware that I am in very scholarly company, and that I'm neither a scholarly legal academic nor a scholarly writer. In fact, in many ways, I think of myself as an accidental playwright. And to understand the circumstances of that accident, it may be useful to detour. You can stop me when all the sort of road traffic puns become unbearable, into a short primer on on English language theatre in Singapore. So when I say Singapore theatre, that's going to be a short form for English language theatre in Singapore, because I do acknowledge that we have many different language and ethnicities here. That's one of the strengths and beauties of living in Singapore, and certainly, for example, the Chinese language theatre goes back much further, as does Malay theatre. But I'll just use a short form and just say theatre in Singapore when I really mean English language theatre in Singapore. So, like many former colonies, I think the history of our homegrown theatre only began after the yoke of colonization had been lifted with our independence around 1965. And around that time, I think there were already a few local theatre pieces that by writers such as Gopal Singh and Lim Chor Pee that signaled that perhaps everything was going to start growing. But then came what some people describe as the lost decade of the 1970s. I'm not sure why, but in fact, I think Gopal Singh said that essentially, theatre had died. And as a teenager, certainly growing up then, I thought there was only one theatre company. It was called the Stage Club. It was peopled by many of the expatriates who was sort of still living in very much in Singapore and continue, of course, today to live in Singapore, who primarily staged reheated productions of George Bernard Shaw and all those other revered pieces in obviously the canon of English language theatre. And there really wasn't anything that was very Singaporean. Even when there were Singaporean productions, they were sort of, taking Sunday cost 5 pesos and then changing it to, a marketplace in Singapore. But essentially, it was foreign pieces, right? If we look forward since then, English language theatre in Singapore has grown and it's generally thrived. And today we have professional companies, we have art schools, and quite a few artists who work full time. And a lot of that, I think, can be attributed to the so-called first golden age of English language theatre. And I was privileged, lucky, I think, to be part of that first golden age. So in about 1985, a lot of things seemed to happen. I don't know, for some of you, maybe that was the year you were born, but or maybe your older relatives were born. But for me, in Singapore in 1985, several things happened. One of the important local theatre groups, Theatre Works, was formed, and 2 very important plays, Stella Con's seminal work, Emily of Emerald Hill, which was about a Peranakan woman, and Peranakan is sort of a local culture. I'm probably going to insult my Peranakan friends by saying it's sort of a culture where it combines part of Chinese and Malay or culture together. So Stella Con's Emily of Emerald Hill was about a Peranakan lady talking about her life. It was a monologue. It was it included bits of dialect, etc. I mean, today we would not think of that as being particularly interesting, but at that time, of course, it was groundbreaking. The other piece that was staged in 1985 was Kwa Pao Kun's, the late great Kwa Pao Kun's The Coffin is Too Big for the Hole, which was essentially about bureaucracy and how someone was trying to bury a relative, but was told by the administrators that the coffin was too big for the hole and therefore not allowed to bury. So that was a time when a lot of things came up. And one of the things that came out around that time was the Shell Singapore University short play competition that was also launched in 1986. And where I think if you take the first anthology of prize winners and you look through just the names of all the people who participated, that's pretty much the foundation of English language theatre in Singapore going forward from then on. The road has not necessarily been smooth. Just a few years after 1985 was 1987, when the government cracked down on some citizens, including some practitioners in Singapore theatre, for being involved in what they called a Marxist conspiracy, and jailed people under our Internal Security Act. And that was quite a, that did have a chilling effect on writing, but I think it really couldn't stop the momentum that came from this deep hunger for writing that reflected ourselves. While I think many of us learned how to play with the censors and probably wrote better for the play, and for learning how to negotiate some of the administrative constraints that we operated under, governmental efforts were not able to stifle or close off the growth. And like I said today, fast forward, 30 years later, we have many theatre groups doing a variety of work, including work, of course, that is not sort of indigenous to Singapore, but also with a very healthy percentage written by, reflecting, and celebrating our own lives. And of course, for someone like myself, who is an amateur and a hyphenate, I probably would not be able to break into the scene today with all the wonderful, talented young people. But thankfully, enough white hair to suggest that I had the privilege of being a small part of that so-called first golden age of theatre. And as it turned out, law played a part in that. At this point, I'm going to say that I am an interloper here. I don't indeed, on today's topic, have any deep insights or any thesis. But I can say that, law and performance came together in my life in a very personal sort of a way. So to start with, that accident that brought me into theatre, law was the proximate cause of that. In June 1985, I had graduated. I was studying for the bar. And it being the 1980s in Singapore, agency was limited and attendance at bar prep lectures was compulsory. One afternoon, I was in a civil procedure lecture, and anyone who has spent a lot of time with civil procedure knows that it is so scintillating that one inevitably must start thinking about other things. And by the end of that lecture, I'd written what would go on to be the first half of a short play, which I then told a good friend about, and I put it away in a drawer and didn't think more about it. But of course, later that year, as I said, the Shell Singapore University announced the first Singapore short play competition, my good friend said, oh, go on, just finish the piece, right? And submit it, which I did. And that first accident occurred, the play did well. And suddenly people not only wanted to stage that play, but were sort of coming to me and asking me to write pieces for them. And this was, I don't attribute that to, you know, any particular genius in my writing, but I think, right, there was this hunger for voices, however unschooled and clunky, that authentically reflected our experience. And so I got a few commissions, and you know, at that time, many of us involved in the Singapore theatre scene, the English language scene, we were in our 20s. It was a fully amateur, it was a fully amateur scene. Most of us had full-time jobs doing other things, some closer related to theatre and others not. The audience for productions was not large. It wasn't uncommon to stage a production in a little conference room, conference auditorium, you know, in between management for professionals and accounting for lawyers, you know, or some other talk. And it wasn't uncommon to do that during a lunchtime for you know, a crowd that happened to just stroll in from their offices, and to run for just 2 or 3 performances, and then we were lucky if we got the 2 or 3 performances, right? I myself was a prosecutor at the time, putting people in jail during the day and writing on weekends and attending rehearsals in the evenings. So it was an extremely exhilarating time for me, although how much of that was due to the high from sleep deprivation, I can't quite say. Although some of my fellow theatre practitioners like Harish Sharma of Necessary Stage or Ong King Sen of Theatre Works would transition to full-time artists, I never did. I always kept my day job, so to speak. So law was certainly part of the context of my lawmaking, and over the years, law has provided the context for several of my early plays. For example, the Invitation to Treat trilogy, which is about a lesbian corporate lawyer called Ellen Toll, whose life we follow in 3 plays titled, as our wonderful host Kari has said, Mergers and Accusations, Wills and Succession, and Jointly and Severably, demonstrating only that I totally lack imagination when it comes to titles, right? But I think unlike some of the other lawyer writers on this panel, where perhaps law is up front and center in their work, or is the subject matter of their writing, I think law has been at most a supporting character in mine, staying in the background as the context, but not hogging the stage. The trilogy is really ultimately about love, and Exit, another piece that employs some lawyerly devices, is really about loving one's country, yet having to leave it. So as I said, I don't really have anything deep or insightful to say about today's topic on law and performance, other than that they happen to coexist quite peaceably in my life, where they play counterpoint to each other, these 2 parts of my hyphenated life. Thank you.
Thank you so much, Eleanor. I think I'm excited for us to start off with, kind of for all of us, I think it's interesting, kind of all 3 of you had mentioned to some extent the extra legal, like things that either are folks who either are not covered by the law or who the law was never intended for, or the aspects of life that seemingly fall outside the law. And I'm curious sort of what attracts you, what you think either in art or scholarship, you think in art or scholarship it benefits from looking at folks who've been like historically excluded from the law, be it either Native peoples or these or immigrant socialists in the case of Anne, some of what you were talking about, or Eleanor, focusing on specifically lesbian experience within the law. How does focusing on folks who might be at the margin or who might be perceived as outside the law, has that sort of benefited your creative practice or scholarly work? And Eleanor, if you're willing to get started.
Okay.
Yeah.
Okay. So I'm not sure about how it sort of benefited my scholarly work, because as I shared, in a strange way, while I am the person in both, I don't really use in a direct way that much, right? Either the theater in my scholarship of law. I mean, I don't write, for example, about law and theater. And equally, when I write my pieces, I don't directly address. I mean, it's not Aaron Sorkin and talking about legal points or anything like that. I just don't do any of that. But I mean, clearly the influence is there, and I think taking up the theme of what Mary Kathryn was saying, but maybe from the other side of it, right, and about visibility. Yes, I mean, I think it's obviously problematic when theater and law erases people from it. But the experience in Singapore, and I'm grateful for it, to some extent suggests that obviously sometimes, the culture doesn't see certain groups, but theater and practitioners can patiently, over many, many years, start a conversation going that then migrates into the so-called real world. And I like to think that, when it comes to LGBTQIA issues, and I myself sometimes still get the alphabets not quite right. And I admit that's because in Singapore, the visibility still needs, we still need to learn how to deal with the visibilities on a day-to-day basis. But starting with some of the stuff that I wrote, Russell Hing wrote writing about a transgendered individual, Michael Huang also writing about transgendered individuals, Alfian Saad writing about gay men, or Ovidia Yu writing about lesbians, all sort of in the late 80s, early 90s, where theater was the only safe space, I think, to talk about these things. And I still remember the first time we staged mergers and accusations in a tiny little black box with a very small audience in the early 1990s. And there's a scene where the women are supposedly, about to kiss as the lights go down. And I mean, like the gasp in the whole audience, I mean, it was just stupid, right? But I mean, but then, fast forward, just a couple of years ago, people restage mergers, and now, they're making out on stage, and it's part of that education, right? And in between that time, I guess what I'm trying to say in my rather rambling and roundabout way is that in between that time, I think because of these representations in theater, in literature, in fact, the conversation in Singapore has moved into the mainstream, right? It took, so when did they start talking about it? They started talking about this in Parliament in the late 2000s, so 2007, I think. So, all right, I mean, it's not a great record. It's almost 20 something years before we see that transition. But the fact that there is that movement, to me, is absolutely clear. There's no doubt about it. We would not have had that conversation if theater hadn't started speaking about these things.
Thank you so much. And I'm going to echo what Anna put in the chat, that folks can start adding some questions into the chat for us to get to in a moment. I think Mary Kathryn, you had something to add on that question.
Yeah, it's a great question, and it's interesting because I think that for tribal nations and for their citizens, Native folks here in this country, we've been on the fringes, but yet, because for instance, my great grandfather was the very first Native attorney in the history of the United States. He studied for law and knew it and everything, but couldn't actually practice in federal or state court because back then Native people were banned from speaking in in state and federal courts, and Black people were too, and many other people of color. So yeah, so he was, Native people at that point were definitely on the fringes, but yet the sovereignty of our tribal nations, the land base of our tribal nations, are literally our property, were frequently the subject of these legal actions. We just weren't allowed to talk. So it's like a weird, yes, we're the fringe, but we're also the subject matter. I mean, if you look at, for instance, Johnson v. McIntosh, it's literally two white guys in the Supreme Court in 1823 arguing this case, and they're both challenging each other's claim to the same piece of land. But one guy's like, well, I have rightful title to this land because I got it from these Indians who were here first. And the other guy's like, that's ridiculous. Indians can't claim title to the land because they're Indians and they're racially inferior. So therefore your title's void. I claim title to this land. And the court ended up siding with the guy who was against the Indians' right to have title to the land. And so like no tribal nation got to speak in court. No one, we didn't get to talk, but the Johnson v. McIntosh decision in 1823, although it was white guy versus white guy, if you read the language, it actually says, well, tribes can't claim legal title to their lands because they're racially inferior savages. Those are direct quotes. And then I'm paraphrasing this part, but because they don't worship Christ, because we were heathens because we didn't worship Christ, and therefore we couldn't claim legal title to our lands. So and talk about performance and storytelling. I mean, that narrative of if you don't worship Christ under the law, there's no way you can own property. Wow. I mean, that's a whole other subject, but yeah, it's an interesting relationship that tribes and tribal citizens have had with the Supreme Court, with the law, and of course understanding too that we've had our own laws and our own traditions and sort of consequences for behavior, and agreements in place and morality and all of that sort of got, there was a bit of an upheaval with the post 1492 and everything else that came after that. So it's just interesting, and I appreciate the question.
Yeah,
I think I was going to say, I mean, building on what Mary Kathryn just said, it's so powerful to think about the ways in which Native peoples were being spoken about by the law. And so you don't escape the force of violence that the law can impose on you. You might be denied the legitimacy to speak upon your own behalf, but you don't escape the law. And so I think this is really crucial. So, I'm thinking that then there's the trap that how does one become a legitimated subject who can speak back to the law? And so often we're conscripted, why not use that term? We're drafted into speaking to the law on the terms that through which it will recognize us. These might not be the terms we prefer. And this is where I think the extra legal that Mary Kathryn introduced early on is so vital, because when we first speak to the court, and I'm thinking about, a long history of sort of LGBT litigation before the court, in which basically you have lawyers trying to sort of explain to the justices that LGBT people are humans too, right? But they have to present LGBT people in the most sort of defanged way possible, focusing on us having families. You can't talk about the fact that, say, a sodomy statute might be about sex. Instead, you have to talk about, but it's sexuality so we can form families, right? So you're conscripted into telling the most respectable version of yourself in the hopes that the law will recognize you. And the extra legal is important because, justice judges are people too. They're not just sort of like these sort of recording voices of the law. So they go to plays, as Justice Ginsburg did, often with Antonin Scalia. They'd go to opera together, but they consume culture that is not legal culture. How could there be a trickle up effect of getting different kinds of images, right? And so does this then seed the path so that the lawyer who's arguing before the bar and has to tell the story in a certain way, law is about telling stories, can add as their ninth argument a different version of what, say, a queer life could be, or a different version of what Native peoples are asking for. And so it's like you have to sort of build up to being able to tell different stories. And this is, again, I think that we have to go to the non-legal and not let the law completely constrict our imagination of what we get to ask for and how.
Yeah, thank you so much for that comment. I see Jisha, go ahead, jump in with a question.
Thank you so much. These have been really provocative and rich presentations. My question, because for me, it was really interesting to think about the role of language in all of these talks. And I'm curious to hear how speech travels across performance and law and psychoanalysis. It's interesting to think about the shattering force of speech, the way in which it can, what happened at the Capitol, the way in which it was able to propel this kind of incendiary speech that was able to propel action in a way that completely shattered subjects and people. And at the same time, in psychoanalysis, you have speech being used in order to put together shattered subjects as a kind of, lending a kind of coherence to subjects who are incoherent to themselves. So providing some kind of narrative or story that will bring together shattered subjects. In Mary Kathryn's analysis, I found the world-making power of speech especially profound, the way in which stories can allow certain lives and subjects to be brought into visibility. So I was wondering if you could speak a little bit more to the relationship of speech and how it traffics between selfhood and subjectivity and the theater and law.
Well, I mean, I'll just jump in and say, I actually think a point that Anne made earlier, it's really important. I mean, first of all, I always throw, and I know a lot of folks here are attorneys, and you certainly don't have to be an attorney to understand the law. And I hate it when attorneys act like that's the case. But what I've heard a lot of folks say, there's been a lot of discussion about the First Amendment and these line of cases since Twitter, kicked Donald Trump off, and so I saw some people be like, free speech, First Amendment. It's like, no, the First Amendment does not apply to private corporations. It only, and without getting too down into the weeds of the Fifth Amendment and like all these different, or the incorporation of the Bill of Rights and everything, like we're really, you have to have a government actor. You cannot have a First Amendment violation if it's just an individual or a corporation. And so Twitter can say, we don't want anyone with red hair to, well, there might be anti-discrimination laws that come into play. So before I come up with some crazy hypothetical, the point is just that the First Amendment doesn't apply to private corporations. Now, other people have talked about, well, what could, what could Congress do? What can, we've heard calls, right? Regulate Facebook, regulate Twitter, regulate social media. And there could be First Amendment implications in that, because that would be the government restricting speech or some form or fashion of it, depending on how the bill is written. And I think what Anne was talking about earlier is really, we're look, we've always had people who lie in this country, okay? I mean, to be honest, this country was built on some lies that haven't really been fully fleshed out, that we haven't shed the light on all the lies that have formed the foundation of the United States. And just read the Declaration of Independence. It says that Indians are merciless savages. That's not true, right? It's an insult, but it's also a lie. And lies are not new to Americans or to our politics. However, there does seem to be something that just is slightly different about what's going on right now. And I think it's also, there is a reality. I was actually just talking to one of my friends who's a writer for the New York Times, who we went to college together and just happened to be roommates in New York when I was living there. And he had been in Egypt for 7 years after we graduated from college, and he was back and doing a program at NYU, but just happened to go back over the holidays and happened to be there for the revolution that happened in 2010, 2011. And we were just talking about the role of social media in that revolution, and then sort of fast forward to today and the role and the insurrection on our Capitol. And I just think we have seen an explosion of like how social media is used in the last 10 years. And I think we don't even fully understand it. And I think theater and TV and film are super critical in terms of creating what are the stories we tell ourselves, but everything's become incredibly self-selecting, because somehow now, right, like there's fake news, there's, I think probably a lot of the folks that supported what happened on January 6th would say that a lot of our theaters are super liberal and crazy. There's just a lot out there that has divided us. And the way, probably I'm not saying anything that people don't already know, But The Social Dilemma, that documentary, I think does such a great job of showing how, you know, these are Twitter, Facebook, these social media corporations are there for profit, right? And so they create an algorithm, a complete structure in their product to try to get you hooked, because the more you click, the more money they get from advertisements. So these algorithms are starting to feed people just what they already believe. So if you're a Trump supporter and you don't like Black people or people that you perceive to be Mexican, and you don't have any understanding of what Mexican really even means, but you've decided they're bad people, then you're going to just keep getting articles that feed that belief and tell you you're right and these other people are wrong. And, you know, that's the thing about what theater used to be, right? It used to be sort of this great commons where, you know, like art and performance was like everyone in the community would see this performance and people might disagree about it, but it wasn't like half of the entire population would never see that and would only see this completely separate narrative that, you know. And so I don't know what the solution is. And I do think there could be First Amendment implications if Congress, you know, depending on what Congress tries to do. People in Congress know that, and it's not new news to them. There'll be plenty of attorneys to work on that, both in Congress and in the White House, to look at that closely. But something has to be done, right? Because I think what we're seeing on January 6th is a free speech crisis. It is a hate speech crisis. It is a false speech crisis, right? And my real question as both a lawyer and a playwright is, like, the law can only do so much at the end of the day. The law can do an awful lot, but at the end of the day, changing hearts and minds, opening up minds is what we have to do. And sometimes that takes art and performance, because you can legislate all you want. You must do this, you must do that, da, 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 da. But until you change someone's attitude or you open up their heart or their mind to the humanity of a population that they've been taught to dehumanize, you know, you're not getting anywhere with these folks. And so that's where I think we have to figure out in the arts community how to start to bridge that gap and how to have that conversation. And I don't have the solutions.
Yeah, I think we are in such a predicament with this. Technology has gotten so out ahead of our capacity to think about how we're using it and how it's using us. And, you know, certainly, I mean, one of the things that's so striking, and sort of a point I was making, is that, so Schenck is the first Amendment case that's actually thinking about a free speech challenge to a federal case. It's a major case in the history of Supreme Court jurisprudence about the First Amendment. But First Amendment, right? It has religion first, then speech. All the First Amendment cases date to the 20th century, pretty much. We don't have a prehistory of those. And they arise in the context of the diversification of America. The reason we start getting First Amendment cases around religion and around free speech in the 20th century and not before is because there are different kinds of people coming in with different religious commitments, of different racial and ethnic backgrounds. Of course, this is a country that always had different racial and ethnic backgrounds, but certain people were written out of the possibility of even speaking to the law as an equal subject. But you start having all these contested claims to the First Amendment. But the original context in which First Amendment jurisprudence arises around free speech presumes that there's a scarcity of speech, that what is scarce is speakers, but there's an audience in common. This is the opposite now. Speech is cheap. Right? In fact, the digital commons makes it possible to circulate your speech wildly. So speech is cheap. Attention is expensive. Given all the speech, how do you get the attention, right, of the consumer? We're consumers of speech. We're not listeners, we're consumers. And this is actually what Mary Kathryn was just speaking about, the kind of clickbait, right? They want the media sites that host our speech communities are monetized. And they monetize our attention, right? They go to our interests. They sell us our interests so they can resell our attention to advertisers. And this is all private, right? The government may have played a huge role in building the interwebs, as I like to call them, right? Their huge federal research dollars went into building this, but they're privately held. And that's also why Trump can be kicked off Twitter and YouTube and Facebook without it being a free speech violation, because these are privately held. But, and Holmes says the free hand of the market will solve our problem. No, it won't, right? So, but we have a huge dilemma, right? We don't want to leave it to companies to make this decision for us, but empowering the government to do that seems dangerous in other ways. And as Mary Kathryn said, I have no solutions here, but but what seems to me eminently clear is first, current free speech jurisprudence is not up to it. And this court, it's super conservative and libertarian when it comes to free speech, is not going to allow for regulation of speech, which could be a good thing, actually, because the speech I might want to regulate might not be the speech we want to speak, right? We don't want, but I'm really at a loss here. I want to go back to the clinic and listen to psychic life.
Thank you. Yeah, I wish we had these answers because we need them. We need them for our different societies. I want to get to Carol. I see Carol has their hand up. Go ahead.
I have a question that it's sort of a thread that I think of in the context of this discussion, and that's if you think about the fact that we now have hate crimes. There are legal hate crimes. Those really, I think, you can trace the roots of what's now defined as a hate crime back to some very early days of social media and communication via social media about horrific crimes, Matthew Shepard, and the storytelling and the plays and the performances and the sharing of those types of events that I think, historically you could look at lynchings of Black people as, I think today we would define those as hate crimes. Those were not defined as hate crimes then, but I think through performance and sharing via some of the early social platforms, social media platforms, that sort of became a context or it ultimately made its way into law and is a more broadly defined crime. At the same time, I think Anne used the phrase hate speech. Well, I'm not sure that has quite become, a truly defined legal term or crime. But at the same time, I think that both for in the context of the use of the phrase hate crime and now evolving into hate speech, I think that's where the social media platforms go to the lowest common denominator. In other words, anything can be characterized and you can argue about whether it is or is not without having to know the actual delineation or definition. So I think there's it's the benefits and the benefits of the social media platforms, and at the same time, it's this expansiveness that also leads to the more broadly those are shared, and the more disparate the people are that are on those platforms, the more likely you are to see a diminishment of the use of the terms.
I mean, I just want to clarify that hate speech is free speech. Like hate speech is protected speech under Supreme Court jurisprudence. There's now a solid history of that. And it's very interesting because this is a very US model. Many European countries do not protect hate speech. They do not see that this is valuable speech. And so that there are very different models. And I mention this because there's a tendency of US exceptionalism. So ours is the only way to think about how these questions get settled. And in fact, there are other countries that we look to as almost as our peers, because we're back, America's back, right? So they're almost our peers, but there are other legal models for thinking about hateful speech and how to address it. Models that might that don't see racist speech, for example, as having value. They see it as it's self-discriminatory. In this country, we make a distinction, a legal distinction, which is not the same thing as a moral distinction, but we make a legal distinction between racist speech and racist acts that equate to discrimination, as if a line can be drawn between racist speech and discriminatory acts. It's not always so easy to draw that line, but there's a very different legal history of treatment in this country of the category of hate speech than in other countries.
Thank you for that. And it's also a very specific response to appeal to the government for redress in the case of hate speech or hate crimes. There are other approaches, especially appealing to the US government versus appealing to tribal governments, all sorts of different approaches there. I'm curious, Eleanor, like, how the context has been around hate speech within Singapore, and whether that's been sort of what approaches are like there.
Yeah, so I obviously come from a very different culture, and I think that there might be a sense that Singapore does not value speech. I think it's almost the opposite. We value speech so much that we control it, and I say that partly with a straight face, and partly realizing that that's probably an offensive statement to make in this particular audience, right? But if you think for it, just one example, right? I mean, we're on the exact opposite end, right? On this question of hate speech, we criminalize speech that calls out religious hatred. It is a crime, right? It's not even, it's not even we don't condone or we don't protect it. It is a crime to denigrate someone else's religion, and certainly a crime to stand up there and suggest that anyone should be harmed or in any way hurt on account of their belonging to a particular race or religion. And part of that, of course, goes back to the whole idea that Singapore's roots, ethnically, religiously, multicultural, from the very, well, not from the very, very beginning, but in a funny kind of a way, right? The colonizers realized that there were a bunch of savages, right? And we were all different savage groups, right? I mean, there were the original Malay inhabitants of the island when the Brits came, and then the Chinese immigrants, the Indian immigrants came along, and we were all together inferior to the white man. But then the white man was therefore smart enough, in a sense, to say, well, we'll have to treat all of you inferiorly, but we got to find a way for you all to all live with each other and respect each other. And so when the white man left and then came back now on permanent residence and other sorts of passes, but we won't get into that, right? When the white man left, what they left behind was, in a funny kind of a way, right? A system where the rest of us accepted that we were here in the multicultural, and of course I don't want to make light of the fact that there are still difficulties between the races. So the majority race is the Chinese race, and has tended to do better, and so there are those sorts of issues, right? But that's our starting point, and because that's our starting point, and the relationship between these groups can be fragile. And Anne's point exactly, right? You only need this if we don't say the same things and we don't intuitively agree that, well, if you say that, it's obviously right, and there's that clash. So because of that, we take a very different position, and we protect against language and statements that would hurt each other. And just to and does it work? It wouldn't work for you. You would hate it, and it doesn't work for some of us sometimes when obviously we're not in a position to say the things we would like to say, and we need to speak truth to power. But I think it does help to moderate some of the most extreme language that could be out there. And just going back to what Jisha was saying about the power of speech, right? So I mean, the Singapore government absolutely values the power of speech, and you can see that in the different way that they and understands it. You see that in the different way that they regulate different media, right? So there's a whole bunch of regulations of what can or cannot be said, certain topics you're supposed to avoid, and all that sort of stuff, in order to keep racial harmony, in order to keep good values, all that sort of stuff, right? That I grew up with, right? But it's tiered, right? So if TV is the most restricted, right? Because in the old days, now that's different, but it reached the most people, right? Movies are sort of slightly better, and then guess who gets away with more stuff? Theater, right? Because 200 people a night, like who the hell cares? You can say what, not whatever you like, but you can say a lot more, right? And then sadly, I think as a reflection on us, books probably the most the most open, you know, words in books, you can say a lot of things. So and you know, I think, you know, half jokingly, but I think this really shows quite how much Singapore values the power of speech in the way that we regulate it.
Thank you so much, yeah, for that important reminder. Yeah, speech happens in different marketplaces, it happens in different theaters, it happens within different nations and collections of nations, so within the nation state. So, and yeah, I also want to recognize this great comment from Avgi Sakatopoulos, also talking about how speech can rouse the person who says the speech in addition to the person who's hearing it. So very, very insightful thoughts as well. Well, we're at the end of our time together. So I really would love to thank all three of our panelists. Thank you again to Jisha and Anna for helping coordinate this event tonight. And thank you to all of you for joining us. Our next event of Art Plus Justice is going to be on February 4th, I'm sorry. And it will be a discussion of the legacy of John Lewis through the work of graphic novels. So it's going to be a very exciting conversation.
That's cool. Who's your speaker? Is it Andrew?
Andrew, yeah.
Really?
Yeah.
That's
Join us. Please join us.
I'll try to join. He's a good friend of mine. So that's so cool. Okay.
That's fantastic. Well, we'd love you to join, and we'd love all of our audience here to join us as well.
That's 1 month from now?
February 4th. Yeah, February 4th. So pretty soon.
Couple of weeks.
Yeah, okay.
2
Couple
weeks.
weeks.
Worth getting up for.
Worth getting up for.
Worth getting up for in Singapore, you know.
Yes.
Very cool.
Well, for all of y'all, have a great, and Eleanor, have a great morning. Have a great evening for our other panelists. And,
Thank you so much for your brilliant thoughts. Very grateful. Thank you.